Hi, everyone. Welcome to the webinar. This is estate planning for busy parents. Can everyone see the screen okay? Great, great. I'm Stephanie Email Nelson, and I'm so glad that you're all joining us today. You're going to learn a ton, and this is going to be a great use of your time, I promise. For the next hour, I want to share with all of you the secrets of estate planning. There are a lot of misconceptions out there. So my goal with this webinar is to leave you with a better understanding of what can go wrong if you don't have a plan, what documents you'll need, how to get them in place. And I want you to be able to make an educated, informed decision about what's best for you and your family. And the best way to get the most out of your time today is to turn off your phone, close your door, close out of social media. You'll get a lot more out of this if you can get rid of all of these distractions. And you really do deserve this time for yourself and ultimately for your family. Also, be sure to stick with me for the whole webinar because I have a bonus for each of you and I don't want you to miss out. And that'll come at the very end of the webinar. So stay tuned for that and I promise it'll be worth it. You should have gotten an email with the webinar workbook. Go ahead and print it out, refer to it throughout the webinar to stay engaged, and make sure you get the most out of the event. Now, if you didn't get it for some reason, that's okay. Just take out a piece of paper and write down some notes. I want you to think about your questions and write them down in the workbook so you can have them ready to ask at the end. Or you can just pop it into the Q&A as we go, and I'll tackle as many questions as I can at the end of the webinar. And finally, I want you to think about the people in your life you care about the most. They're the reason you're here. We don't do estate planning for ourselves. We do it for our loved ones. We recognize that estate planning is something that's not all that fun to think about. In fact, almost 70% of Americans have no estate planning at all. No will, no trust, no nothing. And many of you on this webinar today are probably part of that 70% with no documents in place. And that's okay. That's why you're here, to find out how you can do something about that. Okay, so we're on question number 1 in your workbook. What are the 3 biggest doubts people have about estate planning? Well, first of all, I understand that there's this fear that planning for death is somehow going to hasten its occurrence, that if you keep putting it off, it will never happen. This is common. We hear this from a lot of our clients, and everyone knows that this is irrational, but there's still this feeling. Another common objection is this is going to take too long and I just don't have enough time. And I get that. And we're going to talk about that later in this webinar. So you'll know exactly how long this process takes, what's involved, and how much it costs by the end of the webinar. And finally, you're probably wondering how estate planning benefits someone in their 30s or 40s. Is it really necessary for people who don't have millions of dollars in the bank? And we're going to talk about both of those questions too. So if any of this sounds like you, just know it's totally normal and you're in good company. The good news is that I have never had a client sign their will and then immediately drop dead. Like never happened. So I know, but yes, getting an estate planning in place requires an investment of money and time. But I think you'll find that the benefits of estate planning far outweigh the costs, both financially and emotionally. And finally, you're going to see as we go through this webinar that the benefits of estate planning really have nothing to do with how much money you have or how old you are. At the end of the day, when we talk about estate planning, the big picture is that it's not about you. It's about the people you love the most. My definition of estate planning is that it's all about making sure that things are as easy and as inexpensive as possible for your loved ones when you're gone. And you care about that if you're 25 or 85. And you definitely care about that if you have $10 million in the bank or $10. So this is question number 2 in your workbook. Who are the people you care about the most? Who are you doing planning for? I want you to write that down. Now, this is our agenda for today. You're going to get most of the same information you would get from me in a one-on-one personal consultation. And I know that many of you on this webinar are parents of minor children. And I want to make sure And I know you want to make sure that your kids are always taken care of by the people you want in the way that you want. So we're going to talk about that. We're going to talk a lot about probate court and how you can avoid it. And if you have no idea what that is okay. We're going to talk about that too. You've got a couple of different options in terms of what kind of estate plan you can put in place for your family, including a will versus a trust. So by the end of the webinar, you'll have a really good idea of what documents make sense for your family. And we're going to talk about how you can make sure that your kids don't lose their inheritance in a divorce, or how to make sure they don't get a big check on their 18th birthday. These things are really important to parents, and we're going to talk about how you can prevent things like that from happening. I'm going to talk for about 45 minutes, and then we'll have lots of time for Q&A. And also, we're going to go over how you can start the estate planning process with my firm, what's involved, and how much it costs. So by the end of the webinar, you'll have all the information you need to make a decision about your own estate plan and how you can move forward with my firm, just like you would if we were sitting together one-on-one. And don't forget about your bonus at the very end. So a little bit about me. Again, I'm Stephanie, and I'm an estate planning attorney with Jennifer Porter Law. We are a military spouse-owned firm based in Northern Virginia and Hampton Roads. I've been a practicing attorney for 22 years, and I'm also a former military spouse. My husband is retired. Here is all of my contact information. You can screenshot this or take a photo or use that QR code to save my information. Please feel free to call or email me if you have any questions at all. Now, just like many of you, my reason for being here, for doing this, is my family. I live in Chesapeake, Virginia with my husband, who is retired from the Navy, and our 3 boys. One is off at college at Virginia Tech. Go Hokies. Our middle is about to head off to college again. And my youngest is 10 going on 20, as you can see from this photo. Now, my husband and I both have aging parents. We have college expenses, and we're trying to save for retirement too. And we're concerned about ensuring that our youngest is cared for if something happens to us. So I get it. I understand how overwhelming this process can be and how hard it can be to know just where to start. So today, I'm going to show you how to get started planning. We talked earlier about how most people don't have an estate plan, or at least they think that they don't because they haven't formally done a will or a trust. But the truth is you do have an estate plan of sorts, even without formal documents. It's just that the Commonwealth of Virginia has written it for you. In other words, there are default rules that kick in when someone dies without doing estate planning. You probably won't like the default rules, which is why we plan, so you can override the default rules for your family and your assets. And you can make those important decisions for yourself instead of letting Virginia make them for you. These are some of the things that estate planning accomplishes. I'm just going to go through these quickly because we're going to talk about most of these during this webinar. But think about which of these are the most important to you. Now, estate planning can ensure that you can give what you have to who you want, the way you want. It can help you avoid probate court, maximize the assets that your loved ones are going to get. It can help you care for yourself during your lifetime or during incapacity, help you fulfill any charitable intentions you have, minimize taxes at death, care for others like a surviving spouse or your kids or grandkids, and pass on your values and ideals to your family members, and help protect assets from creditors, divorce, or bankruptcy. If you die with no estate plan, without a will or a trust in place, it's called dying intestate. And this may be the situation that many of you are in now. This is the let's just do nothing scenario. And it means you'll end up with Virginia's default plan. So let's talk about what the default plan is. In Virginia, if you die without a will, your assets are going to be distributed according to state law. So they could go to people you don't want them to. Your kids will get their inheritance at age 18 and they will get it outright. They could lose it in many ways, including spending unwisely. Your spouse could remarry after your death, leaving money to a new spouse and kids. And a judge is going to decide who will raise your minor children and who's in control of their money. And probate court is absolutely guaranteed. Now, I want to talk to all of the parents on this webinar. If you have minor children, that is kids who are under 18, one of your top priorities should be getting in writing who you want raising your children should something happen to you and your spouse. In fact, I think parents of minor children need to plan more than anyone, even people who are elderly, because there is nothing more important than making sure that your kids are taken care of by the people you want and the way you want, no matter what. So the rule is, if you haven't nominated guardians in a will and you and your partner or spouse pass away, a judge will choose for you. In other words, a complete stranger will decide who gets permanent custody of your children. And because you didn't get your wishes down in writing, they have no choice but to figure out who you would have wanted on their own. Just writing it down in a letter or letting your sister know is not good enough. That is not legally binding. Now, a judge is going to do the best that they can with the information that they've got, but they don't know your family, they don't know your preferences, and they don't know what you would have wanted. So this is question number 3 in your workbook. If you don't nominate legal guardians for your children, who will name them for you? So a judge could end up naming someone who looks really good on paper, but you know in real life is the last person you would want raising your kids. Now, this would happen in something called a permanent guardianship proceeding. In a permanent guardianship proceeding, a friend or family member will have to petition the court for custody of your children, and a judge will make the final decision about who's going to raise your kids. This kind of proceeding is rigorous, it is complicated, it takes a long time, and it is expensive. So you want to avoid this if at all possible. And the way you do this is by setting up a will. This is the legal document where parents nominate guardians. Another reason you want to get your wishes in writing in a will is because, what happens if more than one family member wants custody of your kids? I mean, what if your sister wants custody, but so do your husband's parents? And this is something we hear a lot. A client will come into my office and say, there's a lot of people in my family who want to take my kids, so it's really not a problem for us. This is actually more of a problem because if you haven't said who should raise your kids and in what order, your family's going to have no choice but to duke it out in court. And your kids are going to be stuck in the middle of that. The solution for this is to get a will. Name your first choice for guardians for your kids. If it's a couple, you want to say what happens if they get a divorce or one dies. You may want to name your sister Jennifer and her husband Tim. But if Jennifer dies, do you want the kids going to Tim still? Maybe, maybe not. So you're going to write that down. And then you can list as many backups as you want, just in case your first choices aren't available or decline the appointment. Okay, let's talk about the money. What about your actual estate? Who gets your money when you pass away? If you want to leave everything to the cat, that is definitely an option, but let's talk about some other options. First of all, what do we mean when I say estate? Many of us think that we don't have an estate. That's something that only really wealthy people have. But we all have some of these assets or accounts, including bank accounts, a car, boat, motorcycle. You might have a brokerage account. You may have an IRA or 401k. You probably have a house or maybe a vacation home. You have life insurance proceeds. You might have jewelry, intellectual property, or maybe you're part owner of a business. Now, we need to decide where all of this is going to go when we pass away and under what circumstances. Before we get into your 2 options, a will versus a trust, I want to talk about why title is so important in estate planning. The magic rule is this: the asset goes when you pass away. Where it goes depends on how it's titled. There are 3 ways you can own property at your death, and this is question number 4 in your workbook. The 3 ways you can own property at death include individually, jointly, and with a beneficiary designation. So a bank account owned just by you, not jointly with anyone else, is owned individually. A bank account with two or more owners, like a husband and wife, is owned jointly. And an asset like life insurance or a 401k has a set of instructions, a beneficiary designation as to where it goes when you're gone. This is the key. You still need to do estate planning, even if everything you have is held jointly with your spouse or it all has beneficiary designations. You may be thinking, why do I need to do estate planning? Because my husband and I own everything jointly. So if I die, everything just goes to him. And while it's true that jointly held assets do just go to the other owner when you pass away, we have to account for what happens when the second owner dies, or what happens if you die at the same time. Jointly owned assets avoid probate when the first of you passes away, but they will not avoid probate at the second death. And we're going to talk more about probate in just a bit. Sometimes, like life insurance, you have a little built-in estate plan. It will just get paid to whoever you've named as the beneficiary when you pass away. So generally, these assets don't have to go through probate. But that's assuming the beneficiary is over the age of 18 and actually alive when you pass away. If either of these things aren't true, these assets will have to be probated. Just as important is that the proceeds will be paid outright. Let's say you've named your 20-year-old son as the beneficiary on your $500,000 life insurance policy. Do you really want him getting a check for $500,000 with no rules as to how and when he can spend that money? I don't know about that. I don't know. I have a 19-year-old. That kind of strikes fear in my heart. He might blow it all in a week. Like, seriously. A better idea is to set up a trust and name the trust as the beneficiary instead of your son, and then put some rules in place as to what he can spend the money on. Okay, so now I think we've determined that you need an estate plan no matter what assets you have. So what are your options? And as we go through the two options, I want you to be thinking about which one makes sense for you and your family. Now, it's important for you to understand what comprehensive estate planning is. Not just estate planning, but comprehensive estate planning, and why most cookie cutter estate plans just don't work when you need them to. And what I've seen after doing this for a while is that cookie cutter documents can be poorly drafted and they don't address real life issues that families face, like blended families, children with special needs, or estate tax issues. They're very cookie cutter and they don't address the things that you really care about. Another problem you can encounter is that most of these cookie cutter estate plans are just a last will and testament. And this is probably what you think of when you think of estate planning, right? But the problem with a will is that it guarantees your family has to go through probate court before getting your assets. And many people are surprised to hear this. They are operating under the false assumption that a will meet all their needs, but it won't. And you'll see as we go through this that wills come with a lot of hassle and expense. Most estate plans aren't updated to keep up with your life. And the truth is, your life is going to change. Your assets and your family are going to change, and the law is going to change. Your plan needs to keep up, or it won't work when you need it to. And this is why you work with a lawyer. And finally, the vast majority of estate plans just leave the money outright to the kids at 18, ready to be spent in any way, or lost in a divorce or a lawsuit. And we're going to show you how you can easily prevent that. So as you can see, most estate plans just are mediocre. And I'm here to show you what a comprehensive estate plan is and how it can really benefit your family. You have two options. You're either going to do a will-based estate plan or a living trust-based estate plan. This is a decision everyone has to make, whether you're married or single, have kids or don't, regardless of how much money you have. You have to decide if you want a will or a trust. As I mentioned earlier, the vast majority of my clients and people today choose to do a trust instead of a will, but I want you to understand both options. Now, question number 5 in your workbook, write it down. Let's look at a will. What does a will accomplish? Now, having a will is definitely better than having nothing. This is where you name guardians for your minor kids, and you can name beneficiaries for any asset or account held in your name alone. You can also name an executor. In Virginia, we call that a personal representative. This is the person who's in charge of wrapping up your affairs and your estate when you're gone. So those are all the things that a will does, and it's about all a will does. You can see that a will doesn't accomplish all that much, really, and it doesn't accomplish many of the things that people think that it does. So it can come with a lot of downsides that people aren't aware of. First, as I mentioned before, wills have to go through probate court at your death. And we're going to talk about why this can be a bad thing in a few minutes. Your will is only effective at your death, and it doesn't help at all if you're alive, but disabled or incapacitated and unable to manage your own affairs. So, what happens if you're incapacitated and you can't pay your bills or communicate your healthcare wishes? Your will is not going to help in these circumstances. And this is going to happen to most of us. At some point in our life, we will all become disabled. And it's actually much more likely to happen um, without documents in place than with documents in place. So you want to fix that. Each state has their own laws regarding wills. So a Virginia will may not be effective in California or Florida. So if you do a Virginia will and you move, you may have to redo your entire estate plan. And this can be a problem for many military families. Most parents don't want their kids to inherit everything when they turn 18, which is the age that you're legally entitled to inherit money. Most parents would like their kids to get it a little bit later in life when they're more mature. And you're not really allowed to put instructions in a will that say my kids can only inherit if they're 25 and they finish college or join the military. You can't do that with a will. You need a trust to do that. As I said before, most assets are outside of the reach of a will and go unplanned for. Wills don't control most property, including retirement plans, annuities, insurance policies, and anything that's held jointly with someone else. Lastly, a will simply transfers property at death. You can say, I want my money to go to my daughter when I pass away, but you can't say when she's 25 and has finished college and has a job. You aren't allowed to put in any instructions in a will for how and when the money is spent by your kids or grandkids. You need a trust to do that. As I said before, where there's a will, there's a probate. This means that if you die with a will, it must go through probate court before your money can be distributed to your family. And while your court experience probably won't be as traumatizing as Colonel Jessup's court experience, it won't be all that pleasant either, because court is just never really a fun process. So, what is probate court anyway? Basically, the main purpose of probate is to change the title on the property you own when you die from you to your family. Your executor will do a full inventory of your assets and make an appraisal of each asset. If anyone contests the will, those disputes get settled in probate court, and then the assets are distributed to the rightful beneficiaries. And a judge oversees this entire process, and you need court permission to do anything. And your family will most likely have to hire a lawyer because it is a complex process. There are three big downsides to probate court. It's expensive, it can take a long time, and it's a public process. This is question number 6 in your workbook. As I mentioned earlier in the webinar, there are a lot of fees associated with probating a will. Court fees, attorney's fees, executor fees, and they can eat up as much as 1 to 5% of the estate assets. These fees are going to reduce the amount of money that ultimately goes to your family. So let's look at an example here. Rebecca is a single woman. She's created a will leaving everything to her daughter, Megan. Megan is currently 10 years old. Rebecca has a house that she lives in worth $400,000 and also a house she rents out that is worth $100,000. She's got an investment account with $250K. She has a life insurance payable to a minor and a retirement account payable to a minor. And because minors can't inherit property, these assets now have to go through probate court so a judge can make sure the money is being handled properly. So these assets become part of the probate estate. So when we add all of these assets up, total probate estate is 1.8 million. And remember how I said earlier that probate can cost as much as 1 to 5% of the probate estate? When Rebecca dies, her will, leaving everything to Megan, will need to go to probate court. Her family will have to hire a lawyer to probate the will. Let's say it only ends up costing 2% of the total estate. That's still 36,000 lost in probate. This 36,000 is not going to Megan. It's going to lawyers, court, and probate fees. And it can be even more expensive when a minor is involved because the court will maintain control until she's 18. So this is a pretty big downside to dying with a will that most people are just completely unaware of. The cost of probating that will at death can be significant, even for middle-class families. The second downside to probate is that it can take a long time. Even the simplest of estates can take months or years to probate. The minimum in Virginia is 6 months. Your assets are frozen for the duration, which is a problem if you're counting on that money being available for the care of your minor kids. And it's an emotional burden for your family, dragging this process of settling your affairs out over several years. And if you have minor kids, it's going to continue until they're 18. So I think most of us could agree that there are few things more private than your relationships with your loved ones and your financial situation. If you die with a will, your estate will be a matter of public record. That means anyone can go down to the courthouse and find out what assets you left behind, how much they're worth, and who you left them to. You end up sharing very personal information with anyone who cares to look. And it can make your minor children vulnerable to all sorts of unsavory people and scam artists because their names are going to be in your will right alongside with how much money they're inheriting when they turn 18. This is the third downside to probate court. But I mean, think about it. Which one of those bothers you the most? It might be all three. So you may be asking yourself, knowing all of these downsides, why would anybody do a will? I get asked this all the time once people see the downsides of having a will. And the answer is that if you have less than $50,000 when you pass away, you're eligible for a simplified probate process that's pretty easy and inexpensive. So in that case, a will might be okay. But if you have more than 50,000 and you want to avoid any of these three downsides we just discussed, a will may not be the best choice for your family. So you may be sitting there going, well, if a will is not going to do this for me, then what should I do? So let's look at our second option, and that is to do something called a revocable living trust. And again, this is the option that probably 90% of my clients choose. So what is a revocable living trust? I like to call it kind of a will on steroids. It's a document that you create that's very similar to a will. You will list the people you want to inherit your money when you're gone, just like a will. The trust is revocable. That means you can change it or even revoke it entirely at any time. Your revocable living trust is going to have a trustee, and that is you. You are in charge of both the trust document itself and the assets that go into the trust. The way it works is this. You create and sign the trust document, and you're going to give your trust a name. Maybe it's the Jones Family Trust. Everything you own is now outside of this trust, and you want to move your assets into the trust by retitling them. Keep in mind that you still have total control over the assets in the trust. You can still use them, sell them, spend them. Nothing changes. But the benefit is that everything inside the trust goes to your named beneficiaries without having to go through probate or court intervention. And that's huge, don't you think? This is the way estate planning has been done for the past 30 years. Now, I bet you're thinking, aren't trusts just for rich people? And if you are thinking that, you would be wrong, because trusts are definitely not just for wealthy people. So what is a trust anyway? Simply put, a trust is an agreement that spells out the rules you want followed for the assets owned by the trust when you pass away. That's it. Put another way, a trust solves all the problems people assume are solved by a will. So let's look at Bob. Bob has $100,000 in a bank account that he wants to go to his daughter Ava when he dies. But he wants Ava to be 25 and have finished college before she gets the money. So Bob needs a trust. Bob is not wealthy. He's not going to set up some fancy trust because he's leaving millions behind. He's just putting some rules in place. He wants Ava to be 25 before she inherits, and he wants her to finish college. Bob needs a trust, even though he doesn't have a lot of money or a complicated estate. He needs a trust because he wants to control how and when his daughter gets his inheritance. That's it. Every trust has three roles. It has a grantor, who is the person who contributes the assets to the trust. It has a trustee, that's the person who manages the trust assets, and a beneficiary, and that's the person entitled to the assets. Here's another example here. We have Harry and Wendy, Harry for husband and Wendy for wife. They set up a revocable living trust. They occupy all three positions. They have total control. They are the grantors, the beneficiaries, and the trustees. They also occupy the manager's role as trustees, making all the decisions over the trust assets. And as the beneficiaries, they have the right to spend and use the trust assets any way they want. In other words, Harry and Wendy still have complete control over their assets, even though their assets are now titled in their trust. What does it mean to be in total control? It's business as usual for Harry and Wendy. They can amend their trust, they can revoke it if they want to. They have all the rights to manage the property, and their income taxes are even filed in exactly the same way they've always done them. And property taxes on their home are paid exactly the same way. Because this is a revocable trust, the government completely ignores the trust for tax purposes and continues to tax Harry and Wendy as individuals. With the revocable living trust, the secret to avoiding probate is how you hold title to your assets. And we touched upon this already. Remember how we talked about assets being owned individually, jointly, or with a beneficiary designation? Well, that comes into play here when we talk about revocable living trusts. This is question number 7 in your workbook. So think of your revocable living trust like a kid's backpack. When your child starts school, they can pick out a backpack, and it can be any kind of backpack, any color, any size. There are a million options. Your trust is the same way. You set it up so it accomplishes what you want it to accomplish. The goal is to have your trust hold all of your assets, because then those assets will be distributed according to the terms of the trust when you pass away. So your trust document is like the backpack. You've set it up exactly how you want it, and then you move all of your assets into the trust. And then when you pass away, everything held by the trust goes to your family without any probate court involvement. So now all of your assets are in your name, which is bad. You want all of your assets to be held in the name of your trust. In other words, you want all of your assets to be inside the trust or the backpack. Again, funding your trust is simply changing the ownership or retitling your assets so the trust owns them instead of you. Just like this lady is putting all her stuff in her backpack, you're going to put all of your stuff into your trust. Now, this solves all the problems that come with a will. You will not lose 1 to 5% of your estate in probate court. The assets can go to your family in weeks instead of years, and it's totally private during your lifetime and at death. Some other benefits of a living trust are that it's easier to amend the documents. As your life changes, you can make changes to the trust document more easily. The trust doesn't get a separate tax identity, so your income taxes don't change at all. Your trust can cover all of your property, including beneficiary assets and jointly held assets. And it's no more difficult to create and maintain a living trust than it is a will. It's valid in all 50 estates, so you won't have to redo your estate plan every time you move. And because it's a private document, nobody knows what's in it, so it's hard to contest. So you might be wondering, if I do the revocable living trust instead of a will, where will I nominate my guardians? Then you say a will is the document where we do that. And the answer is, when you do a revocable living trust, you also get a very basic will that goes with it. It's called a pour over will. And what it does is it pours any asset that's not in your trust at death into your trust. So it's like a safety net. And you'll also use the pour over will to nominate your guardians. Okay, so let's step away from will versus trust for just a minute. By now, you probably sort of have in your head which one you think would be better for your family. And we'll talk about how much each one costs in a few minutes. But the second big issue I want to talk about is, how are you going to design your backpack? What do you want it to accomplish? And one of the things that parents want their trust to accomplish is to be sure that the money they leave their kids isn't spent unwisely or squandered in some way. So let's look at a couple of the things that parents worry about when they're gone. They worry that they're going to leave their money to their kids, who will then commingle it with their spouse and lose half in a divorce. They worry that their kids are going to lose their inheritance to creditors or lawsuits. And these are very real possibilities. It happens. If you give your kids a big lump sum outright on their 18th birthday, that can be a problem. So let's talk about that. Okay, we're back to Harry and Wendy. Harry and Wendy have two grown kids, Denise and Sam. Harry and Wendy have taken no steps to make sure that their wealth is not wasted once they're gone. This is because they have simple wills, which dump a huge windfall on both Denise and Sam. Harry and Wendy are leaving behind $2 million. In this case, Denise and Sam will each receive $1 million from Harry and Wendy, which represents a lifetime of their hard-earned wealth. Denise is married to Jason. Jason isn't a very hard worker and doesn't do much to support the family. Denise gets her $1 million inheritance and dumps the entire thing into a joint bank account with Jason. She has commingled the money. And when they get divorced 5 years later, Jason is entitled to half. This is the last thing that Harry and Wendy would have wanted. All that hard work, all their lives, just to see half of what they leave to their daughter go to her ex-husband. Sam, on the other hand, he takes his $1 million and dumps it in his checking account. He's not married and he is accident prone. He leaves the water running in his bathtub and then goes out for the night, flooding the apartment below his. His downstairs neighbor sues, and Sam loses his entire inheritance, settling the lawsuit. This is the last thing Harry and Wendy wanted, to work hard all their lives only to see Sam lose everything in a lawsuit. So how do we ensure Denise and Sam's inheritance isn't lost to divorce, lawsuits, or bankruptcy? The solution is something we call a children's trust. Think of the children's trust as a tube of toothpaste. That's the best analogy I can think of. So we're on question number 8 in your workbook now, okay? The mistake that Harry and Wendy made is that they gave their kids outright distributions in their will. Giving outright distributions to your heirs is just like squeezing all of the toothpaste out of the tube right onto the counter. Once it's out, it's impossible to get back in. The money is just out there on the counter, and it can be commingled with a spouse, lost to creditors, or spent unwisely. There is no way to get that back in the tube. Believe it or not, this is the way almost all of the estate plans in America are drafted. Divide it up, dump it out, and watch it get dissipated. But what if we did something different? Instead of squeezing all the assets out of the will or the trust and giving them outright to the kids, what if we divided the shares but kept them inside a trust where they could be protected? This is how a children's trust works. Each child gets their own tube of toothpaste with their inheritance in it, and they can squeeze money out whenever they need it. But whatever hasn't been spent cannot be lost to divorce, creditors, or a lawsuit. You pick a trustee for the trust, and your adult child can be their own trustee at a certain age if you want. It gives your children access to their inheritance while still protecting it. So if you'd like to put these kinds of protections in place, you should set up a children's trust along with your revocable living trust. And this is the option that many of our clients choose. They do a revocable living trust for probate avoidance, and also a children's trust to protect their kids' inheritance. Taxes. Okay, let's talk about taxes because everyone asks me about estate taxes. Now, an estate tax is a tax that's due when someone passes away if they have more than a certain amount in assets, not just money. So there's a federal estate tax, but we are lucky in Virginia that we do not have a state estate tax. But if you're married and die with more than 25.8 million in assets, your estate will have to pay federal estate taxes. I have an asterisk here because that amount of money may change. It may revert back to 5 million adjusted for inflation if Congress doesn't renew legislation by 2025. So this may affect you now, or it may affect you in the future as property values increase and your investments grow with age. If you're in this category, you can reduce the tax liability by doing more advanced planning that's beyond the scope of this webinar. So the information portion of the program is over. And now we need to get an action plan in place and ask these basic questions. What do you need to do? How do you make it happen? When should you get started? And what's the investment to get it done right? You might be wondering, and I get asked about this all the time, can't I just make my own will or trust online? DIY is great for crafts, but I would not recommend tearing out walls and trying to fix your own electricity like this guy. And it's the same for estate planning. Estate planning should be done by an estate planning attorney committed to providing a comprehensive estate plan. There are less qualified options today for families that may not know better. In the legal community, we refer to these as bare bones trusts. They're often produced by attorneys or software that don't focus on estate planning, sometimes even non-attorneys like investment planners, or people try to draft them themselves with online software. Beware of these documents because they may not comply with state law. They do not have the important personalized planning that protects you and your family, and they're typically not funded, which means the trust was set up, but the assets were never moved into the trust. And because they're not funded, the estate will still be required to go through probate. So we don't recommend doing a bare bones trust or trying to do this on your own. A better idea is to work with a lawyer. And here's what I want you to remember. When you work with an attorney, you are paying for guidance and counseling about how the documents should be drafted, not the documents themselves. And if you've worked with a lawyer before, you're probably somewhat familiar with hourly billing. This means the attorney keeps track of how much time they spend on your matter in 6-minute increments. This can be really stressful because you have no idea how much it's going to cost. Also, the traditional practice of law tends to be very reactive. A problem falls in your lap, you're reacting to that problem, and you're trying to put out an expensive fire. And ultimately, you're a number. Your matter starts, your matter ends, and then you don't have any ongoing guidance on how to avoid problems in the future. We flipped the traditional experience on its head. Everything I do is flat fee, agreed to in advance. You don't have to worry about being charged for every little call and email because we don't keep track of our time. You may have a million questions about your plan, and I promise you, I have clients who do. It's fine. That's all part of your flat fee. And also, I love creating estate plans for our clients because it's very proactive. We're not responding to negative situations. It's all about you making sure that your family won't have to deal with an expensive mess when you're gone. And we really do value relationships with our clients. I want to stay in touch with you over time because I know that your estate plan is not something you do once and then just never think about again. Your life is going to change and the law will change. And I want to be sure that your plan keeps up with you. Now, here's how our virtual estate planning process works. First, you attend a peace of mind planning session, which is a one-on-one consultation with me that lasts about an hour. This is $400, but we apply this $400 towards any estate planning work we do for you. So I want you to attend this meeting first because I want to ensure that I'm working with some people who've taken the time to really understand what their options are and the process so they can make good choices. I wouldn't be doing my job if I let you make choices about your estate planning without fully understanding all of the nuances that we talked about today. So we require that you attend a consultation first. And then after you've decided to hire us for estate planning, I have a design meeting with you. We sign your engagement letter. I take full payment for your estate planning package and then design your estate plan. I draft your estate planning documents, send them to your review, and then we meet again and go over your documents. You can ask questions and make adjustments. And then once you finalize your documents, you pick a date to sign everything. And we typically do that in person at one of our offices, either in Fairfax or in Norfolk. And now your estate plan is legally valid. Congrats. Woohoo. Finally, we invite you to keep in touch with us. I'll send you information from time to time about estate planning, and we'll ask you to check in when you have major changes in your life. So if you get married or divorced, you have a big increase in income, yay, or you start a business, it may be time to adjust your estate plan. Either way, you should reassess at least every 5 years. And if you have changes to make, we can do that for you and quote you a fee at that time based on your needs. Okay, let's talk about our estate planning packages and fees. Bargains are good when you're shopping for paper towels. I don't know, I like select a size, but going cheap on a parachute, a surgeon, or a fire extinguisher could have devastating consequences. Estate planning is like anything else. You get what you pay for, and it's worth it to make the investment to get it done right. Frankly, not planning will cost you more than working with us. Let's look at what this should cost your family. Planning could save your family at least $12,000 to $25,000 and a huge nightmare, even if all you own is a house worth $500,000 and you have minor children. And it could save your kids from losing their entire inheritance in a lawsuit. The good news is that our estate planning packages are substantially less than $12,000 or $25,000. This process should save you time and money. We offer 3 levels of protection: the basic plan, the peace of mind plan, and a platinum plan. We found that most of our clients fall into one of these 3 categories, so you can decide which level of protection meets your family's needs. The basic plan is for people who want a last will and testament. This makes sense if you have less than $50,000 in total assets, or you just don't care about probate avoidance. The fee for the basic plan is $3,500 for a married couple, and this includes planning for both spouses. The second level, the peace of mind plan, includes additional protection. This includes a revocable living trust and a children's trust if you want it, which is going to protect the inheritance of your minor children or your adult children from divorce, lawsuits, or overspending. The fee for the peace of mind plan is $5,000 for a married couple, and this includes planning for both spouses. Finally, to add protection from estate taxes, we created our platinum plan. This level provides the broadest protection and requires substantially more planning. This is for families who have more than 5 to 6 million in assets and want to plan for possible estate taxes. However, what's really important to know is that all of our plans are all based on a flat fee. So before any work begins, you'll know exactly what it will cost. And if you're single and are doing a plan for just one person as opposed to 2, the fee is $500 less. So let's talk about what comes with the peace of mind plan, because this is the option that most families choose. The peace of mind plan comes with everything you see here for both spouses if you're married. You get a revocable living trust for probate avoidance. You also have a pour over will. This pours into your trust at your death, any assets you may have left out of your trust during your lifetime. And this is also where you name guardians for your minor children. With a peace of mind plan, you also get that tube of toothpaste, the children's trust, if you feel you need it, and this will help protect your kids' inheritance. Remember how I said earlier that estate planning isn't just about a planning for death? It's also about planning for incapacity. So each spouse gets a power of attorney for finances, so you can pick someone to pay your bills and manage your accounts if you're incapacitated and you can't do it on your own. Each spouse also gets a healthcare power of attorney, so you can pick someone to be your healthcare agent or proxy and make healthcare decisions for you if you can't communicate them yourself. If you're unable to manage your affairs and you don't have these documents in place, Your family has to go to court to get permission, and you want to avoid that. You'll also get a HIPAA waiver, giving your healthcare agent permission to speak to doctors on your behalf, and a living will, also called an advanced medical directive, which outlines your end of life wishes. If you have minor kids, we'll name guardians both inside and outside the will. We include an explanation of all of the documents and instructions on how to title your assets into your trust. You'll get a certified copy of your trust and instructions for your successor trustee to reference when you pass away. And then finally, we provide instructions for your loved ones relating to your burial or cremation. And we give you a big binder with all of your original signed documents, in addition to electronic copies of everything, in case you want to email them to anybody or store them on the cloud, or make sure they're in a couple different places for safekeeping. Okay, so you've learned everything you would learn in a personal consultation, and you've seen our process and our fees. The next step, if you're ready to engage us for your estate planning, is to book your peace of mind planning session. So let's talk about how you do that and what happens in the session. If you're ready to move forward, you can book your peace of mind planning session by calling our firm or emailing me, and I or one of our paralegals can set up a time for your Zoom planning session. And if you have questions at all about our process or packages or fees, feel free to call or email me. Here is my contact information again. Go ahead and call or email me directly, and I'm happy to help. The QR code here is to our contact form on the website if you prefer to use that. Now let's talk about the peace of mind planning session itself. This session takes place over Zoom in a one-on-one consultation with me. Both spouses must attend, and it will last about an hour. Before the session happens, I'll ask you to fill out an online questionnaire or a family profile at least 3 days before the meeting. This will ask some questions about your family and your assets, so we can start to gather the information we need to draft your documents. At your peace of mind planning session, I'll answer your questions, discuss your goals, and we'll talk about whether a will or a trust fits better for your personal, family, and financial situation. And then you'll make the best choice for your family. I'll send you an engagement letter and an invoice for your package, minus the fee you've already paid for your peace of mind planning session. And we do accept credit cards. We take the payment in full before the design meeting. And then we'll roll up our sleeves and design your estate plan. I'm going to walk you through a series of questions about who you want to name in all the different roles, and who you want your estate to go to when you're gone, and who you want to nominate as guardians for your minor children, et cetera, et cetera. And then I'm going to take down all of that information and prepare the first draft of your trust or other estate planning documents. So that's what happens at the design meeting, and we allocate about 90 minutes for that session. And finally, the bonus that I mentioned earlier, and thank you for sticking with me for the whole webinar. Your bonus as a webinar is a $250 credit towards your estate plan. If you schedule your design meeting in the next 4 days to take place in the next 2 weeks, you'll receive a $250 credit that you can apply towards the cost of your estate plan. So that means the peace of mind plan would be $4,750 instead of $5,000. So this is for people who know that they want to work with me and want to save that $250. You are free to book your peace of mind planning session after 4 days, of course, but you won't get that special discount. Now, we don't take on an unlimited number of new clients each month. We're a boutique law firm, which helps us keep our fees down, but it also means that I can only see so many people each month. So if you want to get your peace of mind planning session on the calendar sooner rather than later, be sure to get one of these slots now and lock in your discount. Not everyone is a good fit for our firm. And since we have limited peace of mind planning sessions available each month, we want to make sure they go to families who are serious about getting this important work done. So these are the people who should schedule a planning session. Anyone who's taken the time to watch this webinar so they can make informed decisions. People who do not have an estate plan or want to update their current plan, and people who are ready to get started with the process. We found that a peace of mind planning session is not appropriate for some people. Anyone who's a DIYer who's looking for ideas but not ready to move forward, people who already have a plan in place and are looking for a second opinion, And finally, the peace of mind planning session is not for people who want us to answer questions about their specific situation or circumstances, but haven't decided to hire us yet. And this is for liability purposes. As attorneys, I'm not allowed to give legal advice as it pertains to you and your specific situation unless you've engaged me as your attorney and signed an engagement letter outlining the scope of my services. We can answer basic questions for you, as I've done in this webinar, but we can't advise you on your specific situation unless you hire us. If you do have some basic questions about the process, feel free to book a 10-minute follow-up call with me, and we'll schedule a peace of mind planning session at the end. And if you do have questions about our packages or the fees or the process, please feel free to call or email, and I'll answer those questions for you. Okay, so if you're ready to move forward with your planning, the next step is to book your peace of mind planning session. And you can do that by calling our firm or emailing me, and I or one of our paralegals can set up a time for your Zoom planning session. And if you have any questions about our process, packages, fees, anything, here is my contact information. So go ahead and call or email me directly, and I'm happy to help.